happened to the big idea? Where did the big idea go? There are a lot of big ideas floating around out there, but not all of them are protected, and that becomes part of the problem if you're a small business person or an entrepreneur. Welcome to Next Business Success. My name is Lynn Hinderrocker, and we have a guest here today that's going to help clarify this and really help you ramp your organization up insofar as legal issues are concerned. John Miles with Klein Williams in Lincoln, Nebraska. Thanks for joining us.
Thank you.
You bet. Many entrepreneurs, as you know, start their business with a big concept or a big idea. They're absolutely sure it's novel and creative, something different. And you know, we've talked before about some of the differences between trade secrets and patents and some of those things. I'd like to ask you here today, John, what are some of the mistakes that an ambitious and excited entrepreneur often make? You come across many of them, of course, in your practice. What do they do or not do that they need to be sensitive to as they ramp up on as far as legal stuff is concerned?
Well, I think coming to a lawyer is a good thing for a variety of reasons, but one thing that I think most small businessmen need to do is to focus on what they are actually going to try to accomplish, and then how are they going to muster the resources to get that done. Sometimes trying to do too many things at once is very costly, and so they need to minimize that as much as possible. In the intellectual property area, they can spend way too much time and effort trying to come up with the name, with the product, with the idea.
I've been through that many times.
You know, so it's very important for them to focus on what their business is and then decide how they're going to protect it. And the primary things that I think they're going to look at in terms of protecting is the name at the end of the day, which is a trademark issue, and potentially, if they have an invention, trying to determine whether or not they really need to patent it. In both instances, they can spend thousands of dollars on attorneys and others to help them in that process.
Do you ever come across small business people that think they have something that is patentable, like a utility patent or something they need to protect, an invention, and it's really not, but they're absolutely certain that it needs patent protection? And how do you work with somebody like that?
Well, first of all, I am not a patent attorney. I'm not admitted before the patent bar, but I work with many inventors and others, and so I typically try to refer them to other patent attorneys that might be able to help them.
Okay,
but there are certain things that are just very obvious. I had one client one time that wanted to invent protect a box. A box. It had been invented thousands of years ago, and obviously the fact that it was put together with metal or something else wasn't going to be significant enough in the process to know that it was worth the time and effort to do anything with it.
Okay.
But a patent attorney would be the place to go initially for that.
Now, you also mentioned there are patent agents. They're like patent attorneys, or they're helpful in a certain way. Tell me about that briefly.
If you go on the U.S. Patent and Trademark Office website, you can get to a place where they list all of the registered patent attorneys and patent agents by state.
Okay.
And you can do a search on that basis. A patent agent is a non-lawyer who actually can assist an inventor in prosecuting their patent application to the Patent and Trademark Office. But they can't actually practice law. They can't do other things like litigate. They can't do other legal types of actions on behalf of that client. So you got to make a choice. Some patent agents are very good. Many patent agents work in law firms that have patent attorneys, so they work side by side the patent attorney.
I see. When you see the TV commercials late at night about protect your patent and so on, those are, I'm guessing, mostly patent agents, probably.
Perhaps those are companies that, in my experience, have not been particularly helpful. Most of those companies want to grab your intellectual property, pay you very little for them, or charge you extravagant fees to try to get through the process. I think you'd be better off at the end of the day trying to find somebody locally. I
see. Okay, that's helpful advice. Now, if somebody says, hey, I've got something here and I want to move forward with it, what are the mistakes that they want to avoid as they look for an attorney or try to go through the paperwork process themselves? And what are the 2 or 3 things that they need to keep in mind as they move forward? They think it is, in fact, protectable. What do they stumble across oftentimes?
First thing to do is obviously keep the idea, whatever it is, confidential until they're ready to actually go to somebody. That means assuring that they're not going to disclose the idea to somebody that doesn't have an agreement with them, confidentiality agreement, that they agree to keep it secret. That to me is probably the largest thing that most people fail to do.
Yeah, now the confidentiality agreements, I've been to parties, literally, where people say, I've got a great idea, and they go off in the corner and somebody signs a confidentiality agreement right then and there. Are they enforceable? Do they, are the ones, the templates that you can get off the internet, are they okay, or what's the deal with these non-disclosure statements?
Any contract is only enforceable to the extent of its terms, and only enforceable to the extent that you could litigate it.
Sounds like a legal response.
That is a
there,
legal
John.
response, but the reality is that many times they are. Unfortunately, if someone wants to steal your idea, they're thieves, and they're going to steal your idea no matter what you do, and that's a problem. So the confidentiality agreement is as much as an understanding between the other party that they agree that they understand the idea is yours, and then if they reveal it to somebody else or use it on their own, that you will come after them, and there's a legal basis for doing that.
I see. Now, we've talked a little bit before about the dynamics of melding creativity and vision and passion of the entrepreneur, and then over here there's the power and the size and the scale and the resources and so on, and many of the large corporations that are also in the business of creating new businesses and new products and services. How do those two kinds of entities come together? Is it possible for an elephant and a flea to get along? I guess that's what I'm asking.
It is, although in the context of the trademark world particularly, and potentially in the patent world, if you've got a gorilla on one side and a flea on the other, the gorilla is probably going to win simply because of the financial resources that they can muster as opposed to the small guy, notwithstanding the legal rights of the parties. On the other hand, occasionally you'll have a small person or a flea, if you will, with an idea that is stolen, and an attorney will represent that individual and ultimately achieve a great result against the giant. A recent movie out there about the windshield wiper is a classic
Sure,
case.
that is a great movie and a great example of that. In that particular case, it actually worked out in the end okay.
It did. It worked out fine.
But most of the time it doesn't work out that way, isn't that correct?
And it took years for that to work out. It didn't happen overnight. And that's another important thing about intellectual property. The process of protecting it and the process of enforcing those rights doesn't happen in 30 days. It can happen over a series of months and, in fact, years on occasion. So got to be patient.
John, the technology industry is full of creative people, and all kinds of interesting software applications and developments are being published every day, and they're out there. Do you have any special advice for this particular niche? It seems like there's a lot of very similar kinds of software, and a lot of confusion about who really owns the code that comprise kind of the basis or the core of the software application. Any suggestions there?
Anytime a small business owner wants to engage another party to produce something for them, whether it be art, graphics, or even a computer software program that meets their specific needs, they should assure that the contract that they have, and it should be a written contract, governs the ownership of that intellectual property. There's a doctrine called work made for hire that would, in some cases, make the small business owner the owner of that. In other cases, it does not. So the small business owner must ensure that at the end of the day, once they pay their fees, that they own what they're contracting to produce.
Okay, let's go back and reiterate that. Work made for hire, that's a type of clause that if it's in a contract between a purchaser of a service and a vendor, that has to be clarified who really owns the product when it's all said and done.
Exactly. Otherwise, the person who creates it owns it.
Wow.
And they can do whatever they want to with it.
Well, John Miles, thank you for being on NxBizsuccess. We've learned a lot in a short period of time, not only about the different types of intellectual property protection, but how to apply them and actually develop a strategy going to market with the help of your professional assistants and just some general overall strategic knowledge. Thanks for joining us.
You're welcome.
My name is Lynn Hinderacher, and this is NxBizsuccess. Make sure you know how to protect your intellectual property so that you don't get hung up as you grow your business forward in this new and turbulent era when the big idea can be capitalized, can make you go forward. We'll see you next time on NxBizsuccess.